Judgment in the appeals. The Queen on the application of Carmichael and Rourke, formerly known as MA and others.
Lord Tilson will explain the judgment of the court.
These appeals concern changes in housing benefit regulations introduced by the Secretary of State for Work and Pensions from the 1st April 2013. The changes involve putting a cap on the amount of housing benefit payable to claimants who are occupying a property with more bedrooms than they were calculated to need. The new regulation, Regulation B13 of the Housing Benefit Regulations 2006, to give it its full title, was politically controversial. It was described by some as imposing a bedroom tax and by others as removing a spare room subsidy. The merits are not a matter for this court, and the appeals do not involve any general challenge to the legality of the regulation. The appeals concern its particular impact on those with disabilities and on women in what is known as sanctuary scheme accommodation. The legal question is whether the way in which those categories of people are treated by the regulation is manifestly without reasonable foundation. Regulation B13 applies to people of working age who live in social sector rented accommodation. There's a formula for working out the number of bedrooms the person claiming housing benefit is thought to need, allowing, for example, 1 bedroom for every couple, 1 bedroom for every single adult, 1 bedroom for 2 children under the age of 10, or of the same sex, and so on. The government recognised that there would be various cases where an extra bedroom might be needed because of special circumstances, or where it wouldn't be practicable or fair to expect the occupant to move from the premises occupied by them, but it decided that those cases should be considered individually through a parallel scheme of discretionary housing benefit. It's argued by the claimants that the scheme unlawfully discriminates against those with disabilities by treating them in the same way as the able-bodied, and a similar complaint is made by those in sanctuary scheme accommodation. Take first the disability-based challenges. The court unanimously considers that the argument advanced by the claimants is too broad, and that there is a line to be drawn between, on the one hand, those who have a medical need for an additional bedroom, and on the other hand, those who do not have a direct medical need for an additional room, but may have powerful reasons for staying where they are because of their particular personal circumstances. The first category is illustrated by the case of Mrs. Jacqueline Carmichael. She suffers from very severe disabilities. Her husband is her full-time carer. She needs a special bed and a wheelchair beside the bed, and there has to be space for her husband and nurses to attend her needs. He cannot share the same bedroom because there's not enough space. They therefore have a medically based need for an extra bedroom, and the scheme in relation to her is discriminatory. She lost her claim in the courts below, and this court unanimously allows her appeal. Discrimination can take the form of treating in the same way people whose circumstances are different, and Mrs. Carmichael's case is a good example, it is irrational to treat her as not needing a separate bedroom for her husband when, because of her medical disabilities, she patently and he patently do need a separate bedroom. Other claimants fall on the other side of the line. AD is an adult woman with severe disabilities. She lives with her father in 3-bedroomed accommodation. They do not need that number of bedrooms, but the property has been specially designed to meet her needs. The shortfall resulting from the impact of Regulation B13 in their case is being made up through the discretionary housing benefit scheme. The court has profound sympathy with her and her father, but cannot see that it is unlawful for her case to be considered under the discretionary scheme. Once you move from cases where there is a direct need for an extra room on medical grounds to other cases where, for reasons which may vary in strength, there may be a very powerful case for the occupant staying where they are, there has to be an evaluation of the particular case, and it is not manifestly without reasonable foundation for that to be done under the discretionary housing benefit payment scheme. In disability cases, therefore, the court is unanimous in drawing that distinction. The result is that Mrs. Carmichael succeeds in her appeal, but claimants in the second category, on the other side of the line, do not. Issues regarding Regulation B13 and women in sanctuary schemes are raised in the case of A. She is, or has been, the victim of violence by a former partner, as a result of which she has been provided with protection under a sanctuary scheme. As part of the scheme, her property has been adapted to provide a high level of security. It's larger than she needs, but she'd be loath to move from her present accommodation because she feels safe where she is. The shortfall in her housing benefit is being made up through the housing discretionary housing payment scheme. There's no dispute that as long as she needs protection under the sanctuary scheme, she must have it. But the Secretary of State argues that it doesn't automatically follow that everyone who's in a sanctuary scheme necessarily has to stay for their safety in their present accommodation if it is larger than they need. In the court below, A succeeded in her complaint of discrimination, and the Secretary of State appeals against that decision. A also complained that the government was in breach of its public sector equality duty under the Equality Act 2010 to carry out a proper impact assessment. She lost that part of her claim, and she appeals. The court is divided on these issues. 5 members of the court accept the argument of the Secretary of State that it is lawful for such cases to be considered on an individual basis under the discretionary housing benefit scheme. The majority see her case as a particular example of someone who may have a need to stay where she is for reasons unrelated to the number of bedrooms, but there are many other examples of cases where people may have a good, powerful social reason for staying where they are, unrelated to the number of bedrooms, and it is not manifestly without reasonable foundation for those cases to be evaluated on an individual basis. 2 members of the court consider that women in sanctuary schemes fall into a special category to whom the state owes a special duty because they are victims of gender-related violence, and that in their case, Regulation B13 does involve unjustified discrimination. The minority also considers that the Secretary of State failed in her duty under the Equality Act to consider properly the impact of Regulation B13 on those people. The majority agrees with the court below in rejecting the complaint of breach of the Equality Act. The consequence of that is that the Secretary of State succeeds in her appeal against the finding that there has been unlawful discrimination in her case, and she fails in her appeal under the Equality Act. It should be stressed, as I have already indicated, that this does not mean a lack of recognition on the part of the state of her need. It is simply a question whether it is manifestly without reasonable foundation for that type of case to be dealt with by an individual evaluation rather than by a special exception to B13.
Thank you very much for coming. The court is now adjourned.